Here is another short podcast for today. The question is whether you can seek anticipatory bail for a bailable offence. Now, this is from a short article I had written for the September Law magazine, which you can purchase by clicking on the link given in the description box below. It is priced at ₹50. And now, let us get back to the question. As we can see from a bare reading of section 438 of the CRPC and the corresponding provision under the new criminal act that is in force, which is the BNSS of 2023, when we read the particular provision, we can see that anticipatory bail can be availed only in case of apprehension of arrest for a non-bailable offence. So on a bare reading, it is clear that you cannot generally apply if the apprehension is in respect with a bailable offence. So are there scenarios where you can file anticipatory bail if an FIR has already been registered for a bailable offence? In my opinion, yes. This is because as per the Constitution Bench of the Honorable Supreme Court, in the case of Gurbaksh Singh Sibia vs State of Punjab, reported in 1980 to ACC 565, it was stated that you can file AB even before an FIR has been registered. It is not a condition precedent that an application for anticipatory bail can be moved only after an FIR is filed. This is because it was said that as long as the facts are clear and there is reasonable basis for apprehending arrest, you can go for an AB. Because when you read section 438 of the CRPC, you can see that there is no particular stage that has been given. Now, when you apply this principle to a scenario where an FIR has been registered for a bailable offence, but there is always a possibility that the police are going to alter the charges and include a non-bailable offence, which might have formed part of the same transaction. That is, earlier they had missed mentioning the non-bailable offence. Now they are including the non-bailable offence, which formed part of the same transaction. So if you are apprehending such alteration of charges and also apprehending arrest as a consequence of such alteration of charges, I believe this can also be brought under the purview of section 438 CRPC, which is anticipatory bail. So even in such scenarios, you may seek anticipatory bail is what my contention is. So this shows that merely because an FIR has been registered for a bailable offence, it doesn't mean that you cannot satisfy the court that the FIR may be altered, and as a consequence of which you might be arrested. If you are able to satisfy the court regarding the same, I think you can seek anticipatory bail irrespective of the fact that FIR has only been registered for a bailable offence as of now. I hope you found this to be a curious little podcast. If you are seeking to know more and also discuss more legal principles, case laws and maxims, so on and so forth, you can subscribe to my digital law magazine. It is very affordable. It is written for practicing advocates, for all kind of legal professionals, for law students, for professors, and you can also follow me on Spotify and listen to all my episodes, and you can also subscribe to my YouTube channel. The links to all these are given in the description box below, and please don't forget to rate my podcast on Spotify, because if you give me a good rating, people might come and check my podcast out. So it'll help me reaching more legal professionals so that we can take this movement forward. Thank you for listening. Until next time.